Hello friends, welcome back to series of lecture. This is the 36th lecture of the series of Indian Evidence Act. In this lecture we would start with section 11. Facts not otherwise relevant are relevant. Facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. If by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. They are saying facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. If by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. You see, they are using the word. First of all, they are saying that fact is not otherwise relevant. That fact is not otherwise relevant. मतलब किसी और सेक्शन में सेक्शन 6 till सेक्शन 10 एंड सेक्शन 12 till 55 इसमें से किसी सेक्शन में that fact is not falling. In either of these sections that fact does not fall and therefore that is not relevant in either of these sections. Therefore it is not relevant in either of these sections. Then they are saying such facts also may become relevant. Such fact also may become relevant when, even though it is not otherwise relevant in any other section, it may also become relevant if the following conditions are fulfilled. Then they are saying if they are inconsistent with any fact in issue or relevant fact. Means a fact which is not relevant in any other section may become relevant if the fact is inconsistent with what? A fact in issue or relevant fact. What is meant by inconsistent? Directly opposite. मतलब दोनों फैक्ट एक साथ एग्जिस्ट नहीं करते. डायरेक्टली अपोजिट. दोनों फैक्ट एक साथ एग्जिस्ट नहीं कर सकते. दैट इज व्हाट इज कॉल्ड इनकंसिस्टेंट. देन फर्दर दे आर सेइंग और if they by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. So they are saying that fact of which we are just talking about, that fact alone or together with other facts, या तो अकेला या फिर दूसरे facts को मिलाकर, it renders the existence or non-existence of the fact in issue or a relevant fact highly probable or improbable. Renders the existence or non-existence of relevant fact or fact in issue or relevant fact highly probable. You see the word used is, they are not using just probable or improbable. It is highly probable or improbable. So the essential guideline is that the fact will not be relevant only because it renders the fact in issue or relevant fact probable or improbable. It is relevant only if it is highly probable or improbable. अब देखो इसमें दो चीज कही हैं. Then one fact is inconsistent. If one fact is inconsistent with the fact in issue or relevant fact, मतलब दोनों फैक्ट तो एक साथ हो ही नहीं सकते. तब तो that other fact is renders the fact in issue or relevant fact. तब तो that other fact which renders the fact in issue or relevant fact inconsistent, मतलब it is inconsistent, that other fact will be relevant. Then the other side they are saying that if the fact renders the fact in issue का existence या relevant fact का existence highly probable या improbable. So in that case also fact may be relevant. अब suppose एक कमरा है, there is a room. ये same example हम section 9 में भी देख चुके हैं. There is a room and there a person lives with another person. He lives together with B. In that room A is together with B. अब A is paralyzed. He can very slightly move his hand. अपना हाथ हिला सकता है लेकिन बहुत थोड़ा थोड़ा. अब B is shot and killed. We have been shot and killed. Now the fact that A was paralyzed. अगर वो total paralyzed होता, he can even not move his hand. Then the fact is that he is paralyzed is inconsistent with the fact that A is shot upon B. It will become inconsistent. वो गन कैसे उठाएगा जब totally paralyzed है, 100% paralyzed. Then the matter will fall under inconsistency. हालांकि उसमें जाने की ज़रूरत नहीं पड़ेगी क्योंकि सेक्शन 9 में ऑलरेडी ये मैटर फॉल कर जाएगा. तो 11 में तो वो मैटर फॉल करेगा जो किसी और सेक्शन में फॉल नहीं करेगा. लेकिन सिर्फ समझाने के लिए, एक्सप्लेनेशन के लिए मैं दे रहा हूँ ये एग्जांपल. अब मान लो सपोज सेक्शन 9 में ये फॉल नहीं कर रहा है, सेक्शन 9 है ही नहीं इंडियन एविडेंस एक्ट में, सपोज. क्योंकि ध्यान रखना, जब किसी और सेक्शन में फॉल करेगा, किसी भी सेक्शन में फॉल करेगा तो सेक्शन 11 में जाने की जरूरत नहीं पड़ेगी. बिकॉज इट क्लियरली सेज दैट व्हेन इट इज नॉट रेलिवेंट इन एनी अदर सेक्शन. बट फॉर एग्जाम्पल, of this man, he has got complete paralysis. अब is it not inconsistent with the fact that A may have shot upon B? Pistol कैसे चलाएगा वो? But suppose if he is not 100% paralyzed, but his hands are very weak, but it cannot pick up any heavy object, and he cannot raise to the full and cannot pick up any heavy object, and revolver is heavy. अब उसको उठाकर और बी पर एम करके गोली चलाना. नाउ दैट इज नॉट इनकंसिस्टेंट, बट इज इट नॉट हाईली इम्प्रोबेबल दैट ए मे हैव शॉट अपॉन बी? मतलब हाईली इम्प्रोबेबल मीन्स दैट इट इज नॉट 100% श्योर दैट यू मे हैव नॉट डन इट. फिर भी 90-95% ये गोली ए नहीं चला सकता बिकॉज ही हैज गॉट दैट काइंड ऑफ प्रॉब्लम. सो दैट इज अ केस ऑफ हाईली इम्प्रोबेबल. Next example, suppose there is a case where allegations are that A murdered B. Suppose there is a case where allegation is that A murdered B. Now if A proves that it was a case of suicide, अगर A prove कर दे that it was a case of suicide. Now tell me, is not murder and suicide inconsistent with each other? एक तरफ आप कह रहे हो कि A ने B का मर्डर किया है और दूसरी तरफ आप ये कह रहे हो ये प्रूव हो गया है कि बी ने सुसाइड किया था. तो मर्डर और सुसाइड एक साथ कैसे चल सकते हैं? अबटमेंट टू सुसाइड कह लो लेकिन मर्डर तो नहीं बोलोगे. एंड देयरफॉर दिस टू आर टोटली इनकंसिस्टेंट विद ईच अदर. सुसाइड हुआ तो मर्डर कैसे हो सकता है? इट कैन बी अबटमेंट टू सुसाइड बट कैन नॉट मर्डर. देयरफॉर दिस टू आर इनकंसिस्टेंट. सिमिलरली, suppose there is an allegation against A that he has in his own handwriting forged a document. A के ऊपर allegation है that he has forged a document in his own handwriting. अब if A proves that I am totally illiterate, अब the fact that he is totally illiterate, and the fact that he in his own handwriting forged the document, are these two not inconsistent with each other? जो पढ़ लिख ही नहीं सकता वो कैसे डॉक्यूमेंट लिखेगा? A person who cannot write, how can he write the document? And therefore these two are inconsistent with each other. So write down, for section 11, it is first required that the fact concerned is not relevant in any of the sections on relevancy. In such a case only it can be examined whether the fact happens to be relevant under section 11. Section 11 can be seen as a residuary provision upon relevancy of facts. It broadens the scope of relevant facts. To be relevant under section 11, firstly, the fact may be such as is inconsistent with the fact in issue or relevant fact. Inconsistency here means something which is totally opposite to relevant fact or fact in issue. That is, The two facts cannot coexist. Now next paragraph. If the above is not proved, then the court will examine as to whether the said fact is such as would render the fact in issue a relevant fact, highly probable or improbable. Then such other fact will be relevant. Probable here means possible, and improbable means impossible. But the use of the word highly qualifies it, and it suggests an extreme degree of possibility and impossibility. Thus, any and every fact will not be relevant under section 11 clause 2. Rather, the word highly has to be proved. Thus, any and every fact will not be relevant under section 11 clause 2. Rather, the word highly has to be proved. That is all. अब मेन जो पॉइंट है उस पे आते हैं. At a particular time and a particular date. Suppose at a particular time and a particular date you were present into a room or a classroom. Suppose you are present in a classroom और उसी टाइम पर आप पे एलिगेशन लग जाए that you have committed an offense at some other place at the same time and on same date. एलिगेशन उसी टाइम का लगा हुआ है कि that you have committed an offense. अगर आप प्रूव कर देते हो that you were present at that time on that date in the classroom, now is it not a case of inconsistency? मान लो रिकॉर्डिंग है उस क्लासरूम की. अब सपोज the person was present in the classroom and there is time gap between two classes of 40-50 minutes. He was present into the classroom and the allegation was that he committed the murder 10 kilometers away. अब 30 मिनट्स का गैप है दो क्लासेस के बीच में. इस टाइम पीरियड में वो दोबारा क्लासरूम में आ जाता है आफ्टर कमिटिंग द मर्डर. अब अगर ऐसा एरिया है जैसे दिल्ली है, मेट्रो सिटीज है कोई भी, तो उधर ट्रैफिक ज़्यादा है, देन इट वुड नॉट बी पॉसिबल टू कम बैक विद इन द टाइम इन दिस टाइम पीरियड. बट सपोज कोई मर्डर कमिट करने का एलिगेशन है कि 2-3 किलोमीटर्स अवे फ्रॉम द क्लासरूम और टाइम पीरियड है 30 मिनट्स, देन इट वुड बी पॉसिबल. सो फॉर 2-3 किलोमीटर्स इवन इन द मेट्रो सिटीज इट क्वाइट पॉसिबल टू रीच देयर. 14-15 मिनट्स में यू गो देयर एंड 14-15 मिनट्स में यू कम बैक ऑल्सो. और मान लो 40 मिनट्स का टाइम गैप है, so that is quite possible. So if then the person says that at that time I was in the class and later also when the another class start I was on the class, so how can he can be there within that 40-50 minutes time period and come back? So the answer is it may be improbable, but it is not highly improbable that he may have reached there, and therefore that he was in the class in that time जब फर्स्ट क्लास ख़त्म हुई और सेकंड क्लास चालू हुई, दोनों टाइम पर वो क्लास में था. सपोज 1 बजे पहली क्लास ख़त्म हुई 1 PM एंड अनदर क्लास स्टार्ट्स एट 1:40, तो ही वाज इन क्लास एट 1 PM and 1:40 also he was present in the class. So that fact is not relevant under section 11. But if he proves, because there is video camera everywhere, if he proves that he got into the class at 11, if he proves that he went into the class at 11 or whatever time, and after that there is only 2-3 minutes break, and then again he was in the class when the another class starts, और 2-3 मिनट्स का ब्रेक भी वो भी विद इन द कैमरा ही अंदर था, टॉयलेट करने गया. सो मेन गेट से ना तो बाहर निकला ना दोबारा अंदर आया क्योंकि वो बाहर निकला ही नहीं था. सो मीन्स व्हाट, दैट द स्टूडेंट इज इनसाइड द रूम क्लासरूम So that it is proved from all these cameras that he never went out. So he was present in this classroom, then how he can be present to the spot at the same time? These two facts are inconsistent, and therefore it is complete inconsistency. So he will not be held liable until unless it is proved that there is another way to move out of that room. So even if there are circumstantial evidences against him, he will not be held liable if it is proved that he cannot move out of that room. अब सपोज दिल्ली टू पानीपत 1.5 या 2 घंटा लगेगा जाने में. अब दिल्ली टू पानीपत 1.5 घंटे में मान लीजिए जर्नी है. अब सपोज 2:45 पे दिल्ली से कोई निकला एंड 4 o'clock एट पानीपत PM देयर वाज एन ऑफेंस कमिटेड, अ मर्डर कमिटेड. अब 2:45 पे निकला कोई व्यक्ति और उसके खिलाफ एलिगेशंस है. 2:45 पे निकला और 4 PM पे मर्डर वाज कमिटेड and he is traveling by a car. If it is possible into the car to reach that place in 1.25 hours, अगर कोई हैवी ड्राइवर होगा तो वो पहुंचा भी सकता है, तो कर सकते हो. अगर 1.5 घंटा नॉर्मल टाइम है तो 1.25 घंटा 15 मिनट तो नॉर्मल मैनेज हो जाएगा. लेकिन इट इज़ हाईली इम्प्रॉबेबल. इट इज़ हाईली इम्प्रॉबेबल. वाई? बिकॉज मान लो कोई 2:45 पे निकला है यहाँ से और कोई मीटिंग थी और मीटिंग ओवर हुई 2:45 पे, एग्जैक्ट कैमरा में टाइम है, और वहाँ पर पहुँच जाओ आप 4 PM, तो ऐसा तो होगा नहीं. निकलेगा, उतरेगा, गाड़ी वाड़ी निकालेगा अपनी, तो गाड़ी वाड़ी निकालने में उसमें भी 5-7 मिनट लग जाएंगे. हाईवे पर पहुँचने में भी 10-5 मिनट लग जाएंगे, तो 15 मिनट तो मिनिमम लग जाएंगे. तो वो 15 मिनट भी गए. अब दिल्ली का ट्रैफिक कहीं है तो दिल्ली के अंदर भी बॉर्डर तक पहुंचने में दिल्ली के वहाँ पे भी टाइम लगेगा, आधा घंटा वहाँ लग गया. फिर भी मान लो ही गो वेरी फास्ट एक्सेट्रा एक्सेट्रा, फिर भी लगभग आपके पास 1 घंटे का टाइम है टू रीच द पानीपत. अब इज इट प्रैक्टिकली पॉसिबल टू डू दैट? Therefore you can say that either you can say that it is inconsistent that in 1 hour you are being at Panipat from Delhi is inconsistent. Yeah, in extreme cases you can say that it is highly improbable that you reach there. So these kind of situations, because when you talk about alibi, alibi is this only, that if I present at this place right now, then how could I be present at some other place at the same time? If I was present at one place round about the particular time, and there is allegation that I was present at some other place within such time period that is not possible to reach there within that time. So looking at the traffic condition, looking at the time of the day, looking at the other conditions, so is it practically possible to reach that place within that much of time? It is fine that it is possible, but it is highly impossible. 5% chance है you may, but 95% chance है you may not. So that is a case of highly improbable. हाईली इम्प्रॉबेबल में और इनकन्सिस्टेंट में फ़र्क ये है कि इनकन्सिस्टेंट में आप एग्जैक्टली जिस टाइम पे ऑफेंस हुआ एग्जैक्टली उस टाइम पे आप किसी और जगह पे थी. सो दीज टू फैक्ट्स आर इनकन्सिस्टेंट. एंड हाईली इम्प्रॉबेबल इज कि जिस समय ऑफेंस हुआ उसके कुछ टाइम गैप के अंदर या पहले या बाद में आप कहीं और थे. अब मान लो एक प्लेस पे मर्डर हुआ है एट 12:15 एंड यू आर इन द क्लासरूम एट 12:40 and this place is far away, suppose 50 kilometers away. Then how much time you have? 25 minutes. So within 25 minutes reaching to this place and the circumstances of traffic etc like Delhi, you have to cross Delhi etc. So it is almost impossible. But suppose if it is 10 or 15 kilometers, 15 kilometers are within Delhi. It is not impossible of 15 kilometers traveling, but it is highly improbable because there are so many red lights, traffic, so many traffic conditions are there. So that way it be highly improbable, but that is not totally impossible. So you can or you cannot do it also. जैसे कोई बाइक वगैरह से आया, रॉन्ग साइड वगैरह से निकाला, रेड लाइट जंप करा दे और हैवी ड्राइवर हो, and it may be possible. So at one point of time you are present at one place. The point is that he finds here at this point of time. Then what is the difference between these two places? How much time it will take in the normal traffic condition? And what is the vehicle by which he reached there, etc., etc. What is the possibility of the vehicle by which he reached there? All those factors will be examined in order to see. All those factors have to be examined to see whether it will be probable to him to reach the other place or not. Now, if he finds that the distance was too much and the traffic time was too congested, then you can say that it is highly improbable. तो या तो आप तुरंत उसी समय का प्रूव कर दो या थोड़े बाद का प्रूव कर दो, उसी समय का प्रूव कर दो या उसके आसपास का प्रूव कर दो या थोड़े गैप के बाद का प्रूव कर दो, लेकिन वो अगर इनकंसिस्टेंट है या हाईली इम्प्रॉबेबल है, then in that case you will get the defense, because if you are not present there then you have not committed the offense. So in that way you have to see all the practical circumstances. अब लिखिएगा थोड़ा सा. Alibi is a circumstance. Alibi is a circumstance in which the defense of the accused is based upon the fact that he was present elsewhere at such a point of time, which was either exactly same when offense was committed or which was round about the time of the offense, and therefore these two facts were inconsistent. That is, he could not have been present at both the places at the same time. इसी को बोलेंगे ना inconsistency. He could not have been present at both the places at same time. Next paragraph. It can also be a case wherein the accused was present at some other place at some such time which had some gap from the time of the offense. The gap was such as rendered it highly improbable that the accused could be present at both the places at a specified timings. So you see, when you talk about alibi, alibi क्या है ये तो आप समझ गए. What alibi is, that you have understood. But the point is that will the court trust the plea of alibi that easily? अब suppose there is an accused and accused के खिलाफ there are strong circumstantial evidences. Accused के खिलाफ there are strong circumstantial evidences and the accused will be convicted. जैसे आप संतोष सिंह केस याद करो. अब there are very strong circumstantial evidences against him and the Santosh Singh can be convicted of that point on that basis. But suppose if he is at Vasant Kunj at 5:10 or 5:15 and at 6 o'clock he was there at ILI. अब इस टाइम पीरियड में तो पॉसिबल हो जाएगा. आधा घंटा कर लो इसको. Suppose he is at Vasant Kunj at 5:30 and 6 o'clock he is at ILI. Now in the normal circumstances it is not possible to reach the ILI at traveling 30 minutes from Vasant Kunj. अब नॉर्मल की बात कर रहे हैं, एक्सपर्ट ड्राइवर है उनकी बात नहीं कर रहे. So he raised the alibi that कि मैं 5:30 पे वहाँ पे इससे निकला हूँ तो 6 बजे यहाँ पे कैसे पहुँच जाऊँ. And it is highly improbable, so the plea of alibi may be with him. But again the point is the circumstantial evidences, the DNA testing etc. is against him. अब अगर alibi prove कर देते in the moment he proved the alibi, it means that he was not present on the spot. If he is not present on the spot, then in no circumstances he cannot be convicted. अगर मैं prove कर दूं कि मैं वहाँ पर था ही नहीं, I was never present there, then in no circumstance I can be convicted in the case, even though the circumstantial evidences are very strong. Now you see, therefore the court, whenever there is a case of circumstantial evidences are strong against the accused and the plea of alibi is raised by the accused, and the court finds that the circumstantial evidences are strong against the accused, the court will always be tilted against the plea of alibi, and the burden will lie upon the accused strictly to prove. It will be more strict to prove the plea of alibi. अगर जरा सा भी डाउट मिल गया एलिबाई में कोर्ट को और सर्कमस्टेंशियल एविडेंसेस स्ट्रॉन्ग है, आपका एलिबाई का प्ली रिजेक्ट कर दिया जाएगा एंड यू कैन स्टिल बी कन्विक्टेड। अगर आपका प्ली ऑफ एलिबाई इज वेरी वेरी स्ट्रॉन्ग, आप याद करो दैट केस फत्तू सिंह मोहन सिंह चौहान केस, यूनियन ऑफ टेरिटरी दादरा एंड नागर हवेली, उसमें द डिस्ट्रिक्ट मजिस्ट्रेट का ऑफिस, जब डिस्ट्रिक्ट कलेक्टर के ऑफिस में ही वॉज देयर and he was able to prove with the help of those two other officers, then the prosecution applies for summoning the district collector। तो उस केस में तो हमने सिर्फ समिनिंग कलेक्टर के समिनिंग तक का किया है। अब मान लो उधर उस केस में डिस्ट्रिक्ट कलेक्टर आके बयान दे देता है कि दैट नो आई वाज नॉट देयर एंड देयर वाज नो वन इन माय ऑफिस वाज क्लोज्ड ऑन दैट डे, देयर वाज नो मीटिंग इन माय ऑफिस। अब बताइए, विल नॉट बी द प्ली ऑफ एलिबाई रिजेक्टेड since the circumstantial evidence are strong against the accused, and plus the collector creates the doubt upon the plea of alibi, because the collector says that normally I was not present, and normally when I was not there, जब भी मैं ऑफिस में नॉर्मली नहीं रहता हूँ, there was no one sit in my office, तो इतने में भी डाउट क्रिएट हो जाएगा, and there also that is also sufficient to reject the plea of alibi। That is also sufficient to reject the plea of alibi। अब यहाँ पर एक पैराग्राफ लिखो, the plea of alibi act as a complete defense in favor of the accused, and therefore the court will look at the plea with suspicion, particularly in the cases where the circumstantial evidences against the accused are strong. The burden will lie upon the accused more strictly, and the court will exercise its powers of Section 311 CRPC and 165 Indian Evidence Act to examine the truthfulness of the plea of alibi. A slightest doubt regarding alibi will defeat the plea of alibi if circumstantial evidences are strong against the accused. However, in such a case also, if alibi is proved beyond all reasonable doubts, then the court will give the benefit of doubt to accused and acquit him of the charge। अब what you have to appreciate is, अगर कोई accused है और उसके खिलाफ circumstantial evidences weak हैं और वो alibi का डिफेंस लेता है, तो वहाँ पर कोर्ट थोड़ा सा लिबरल हो सकता है, क्योंकि कोर्ट को अदरवाइज पता है, अदरवाइज भी वो कन्विक्ट होने वाला नहीं है। लेकिन फिर भी ऐसा नहीं है कोर्ट वैसे ही उसको छोड़ देगा, एलिबाई तो उसको फिर भी लेनी होगी, and evidences will require। But if the circumstantial evidences is very very strong against the accused, and if there is no alibi and court is sure that the accused will be convicted, then in such a case accused took the plea of alibi, then there the problem arises। Then in that case the court will, because it is a matter of acquittal and conviction of the accused, the court cannot deny the plea to the accused simply because the circumstantial evidences are strong. So the court has to allow him to prove the evidences of alibi, and if he proves the evidences of alibi, the court will be very circumspect. The court will be asking questions to him to see whether there is some doubt in the alibi, और अगर कोर्ट को लगता है there is some slightest doubt in the alibi, regarding the alibi, the court will go for conviction। alibi reject हो जाएगा आपका। लेकिन मान लो हर तरह के से ठोक बजा कर देखने के बाद भी एलिबाई पूरी तरह से प्रूव हो गया, देन व्हाट, देन द कोर्ट विल go for acquittal and the benefit of doubts will be given. Now upon this point there is a case Dudh Pandey versus State of UP, that is 1981 Supreme Court. Now in this case what happens is, this is a bungalow in civil line Allahabad. Now civil line Allahabad mein there was a bungalow in which this family used to stay. The mother was there and father was not there. She had 3 daughters, D1, D2, या D1, D2 and D3, and she also had a son. और उसका नाम था शायद पप्पू भैया, पप्पू ढिया, सो इज द सन. अब इसकी जो बेटी थी, मान शायद बीच वाली बेटी, शी वॉज टीचर एट सेंट जॉन्स, सेंट एंथनी में शी वॉज टीचर. दिस ब्रदर, ही वॉज यंगेस्ट, ही हैज ए स्कूटर. एवरी मॉर्निंग ही यूज टू गो and drop his didi to the school and from there he will come back. वो जो दीदी थी उसकी शायद एल्डेस्ट वन थी जो टीचर थी. अब this bungalow, in this there was outhouse in which the accused Dudh Pandey, he was paying guest, tenant. अब this tenant has a bad eye upon this D1, bad eye, whatever he wants to make friend, marry, whatever. You cannot tell it a bad eye such. You can say he had a fancy upon her and he wanted to marry her. Now when he approached the girl several times, family came to know about it and they kept this man out of the house. उसको निकाल दिया. After this man was so inclined towards her, he went to the chief judicial magistrate and filed the complaint also that she is my married wife. Complaint किया कि that she is my married wife and see the family people have taken her and not allowing her to come to me. And there was proper proceedings before the CGM, and after the hearing the CGM has dismissed his complaint. तो ये शुरू का इतिहास है. तो ये चीज इसका प्रीवियस कंडक्ट बताता है, एक्यूज का प्रीवियस कंडक्ट. और उसके बाद क्या हुआ, दिस मैन वाज स्टिल फॉलोइंग हर. अब दिस ब्रदर was always with her whenever she goes to college, school, whenever she goes to school and come back to school, the brother will be accompanying her. अब उसके जो रास्ते का पत्थर था वो कौन है, the brother. He was the biggest obstacle because whenever he wants to talk, brother was there. ब्रदर भी छोटा नहीं था, he was 18. अब इस केस को जरूर पढ़िएगा और 2-3 बार पढ़िएगा आप डिटेल में. This case will tell you how appraise the evidences. Read it several times. It will make you know that the manner in which the evidences are examined, that will teach you a lot many things. What happened was, one fine day in evening, he is taking his sister to the market. अब वहाँ पर this man accused stopped them and he tried to talk to her sister, his sister. Upon them this victim, the brother, opposed and then the accused threatened him, मैं तुमको देख लूँगा, I will teach you a lesson. Previous to the day of the incident, this was happened. Now this is what? This is also something, a cause quarrel, plus it is a previous conduct also, plus it will give rise to motive also in the mind of the accused. Now in the morning, next morning he took his sister to the school, to drop her to the school. She has to examine some copies of the children and therefore she went a bit early, 45 minutes early. So he went to school, drop her and then he is coming back. मान लो he was coming around 9:45 or 9:30. Now when he was crossing the Hathi Park ka main gate, there is a Hathi Park, and when he was crossing the main gate, this accused was standing there and he stopped him. The victim, the brother, he stopped the scooter and by the meantime the accused came running. स्कूटर रोक कर उसने स्कूटर को स्टैंड पे लगाया और इतने में accused दौड़ता हुआ आया and he fired a bullet upon him from a country made pistol. कट्टे से मारा था उसने, तो उसको पास से मारा, पॉइंट ब्लैंक मारा. उसके बाद he started running away from there, and in the meantime he loaded one more bullet into the katta in country made pistol, but he did not fire up that upon him, and on the while when he was running away from there, he hid that pistol underneath the heap of the cow dung. There was cow dung का heap, उसके नीचे छुपा दिया उसने. अब at the time when he did this entire incident, two persons were standing at the gate, and one was incidentally the servant of the victim. एक उनमें से जो victim के घर में servant था वो था, और एक उसका friend था जो कानपुर से आया था. These two persons was present in that Hathi Park in the morning, and in the meantime this Pappu was shot by the accused, and there was a eyewitness to the entire incident. अब उसके बाद the accused ran away, that he was working in a factory somewhere, and the distance from the place where the murder was committed and the factory was around 25 to 30 minutes traveling. तो आधे घंटे के लगभग का रास्ता था वो. अब the accused in the afternoon, it was post lunch at around 2:30 in the afternoon, the accused was arrested by the police from outside the factory across the road, and at that time he was standing in front of a pawn shop, and he was chewing pan and smoking cigarette, and then the police went there, and the moment the police reached on the spot, this man tried to cross the road and get inside the factory, but the police arrested him outside the factory itself. तो रोड की दूसरी तरफ जब पान की दुकान पर सिगरेट पी रहा था या पान खा रहा था, जो पोस्ट लंच करते हैं, लंच के बाद बहुत से पान वान खा रहे थे, खाते तो उसी तरीके से वो खा रहा था. The police vehicle stopped there. By looking that, he tried to get into the factory, but he was arrested. So this is the story. After that, he made a confession before the police, and he made a discovery statement also. And in the discovery statement, he declared that the pistol by which he has shot, that is lying in the heap of the cow dung, and the police took him into the spot, and there in front of the police, he got the pistol discovered from the heap of the cow dung. तो एक डिस्कवरी स्टेटमेंट भी उसके खिलाफ है. मजिस्ट्रेट के सामने तो कन्फेशन नहीं दिया था उसने, मजिस्ट्रेट के सामने कन्फेशन रिकॉर्ड नहीं हुआ था, बट द डिस्कवरी स्टेटमेंट वाज देयर. अब इसमें देखिए एविडेंसेस क्या क्या आए हैं इसके खिलाफ. तो जो इंसिडेंट हुआ, शॉट किया उसको उससे एक दिन पहले कि तुम ड्राइवर हो, तुम 2 पैसे के आदमी हो, तुम क्या शादी करोगे, ये सारी चीज़ जो कुछ बोली थी उससे मोटिव और स्ट्रांग हो गया. पहला एविडेंस तो है प्रीवियस कंडक्ट, दूसरा द क्वारल, तीसरा द मोटिव, देन आई विटनेस, और एक नहीं दो आई विटनेस हैं, आई विटनेस टेस्टिमनी, देन डिस्कवरी स्टेटमेंट, देन एक एक्सपर्ट एविडेंस ओपिनियन वाज ऑफ बैलिस्टिक रिपोर्ट वाज देयर दैट द बुलेट वाज shot from the same pistol. Now what happened in one part of the story, when this killing was done, the two persons, the servant and the friend of the servant, they ran from there to the Anthony school, St. Anthony school, and they informed the sister there that Pappu Bhaiya has been shot. Of this sister from the school, whether is in rickshaw or on foot, running to the spot. She came running to the spot, and she saw the brother dead. After that, they sent these people with body to the hospital, and she herself ran towards the police station. She herself rushed towards the police station, and in the police station, she got the FIR lodged. And now she was in hurry. She did not let the police officer lodge the FIR. She herself recorded everything on a piece of paper. उसने खुद से FIR लिखा और उसको लॉज कराया. अब in the FIR she clearly stated the previous conduct, पिछले शाम को जो झगड़ा हुआ था वो भी लिखा उसने. Plus she also stated the incident that has happened today. और इंसिडेंट के लिए उसने क्लियरली बताया that my brother dropped me and when he is going back he was shot, and this servant and friend, they were standing on the spot and they had made so and so statement to me. तो उसके सर्वेंट ने जो भी उसको कहा था, whatever her servant told her, all that she had stated in the FIR, that this is servant who said this. he said that the accused shot my brother, वो सब लिखा उसमें, and that was spontaneous. So she came running, she shot brother dead, sent him to hospital, ran to police station for FIR, and she lodged the FIR. अब इसमें previous conduct relevant कहाँ पर होगा? Section 8. What previous conduct? Filing of the complaint before CGM and all those things, plus the previous day's conduct. Obstructed them on the way in the market, and then the quarrel happened. वो भी conduct आएगा इसमें, plus the quarrel. The quarrel can be taken as a cause. Also it can be taken as constituting motive. जब उसने कहा था ना कि तुम 2 पैसे के आदमी हो etc etc, that will constitute motive. So that will be relevant cause relevant under section 7 and motive relevant under section 8. Motive to remove him from the way because he is the obstruction. और आई विटनेस का टेस्टिमनी अगर कोई पूछे तो डायरेक्टली रेलिवेंट होगा सेक्शन 5 में. आई विटनेस का टेस्टिमनी किसी 6, 7, 8 वगैरह में नहीं आएगा. आई विटनेस का टेस्टिमनी डायरेक्टली सेक्शन 5 में एडमिसिबल होता है. आई विटनेस का टेस्टिमनी डायरेक्टली रेलिवेंट ऑलवेज अंडर सेक्शन 5. ये 5 पढ़ा रहा था तब बताना भूल गया था. डायरेक्टली रेलिवेंट नहीं, डायरेक्टली एडमिसिबल अंडर सेक्शन 5 because that is the testimony of what? That is the testimony of star witness of the fact in issue. So that is directly admissible under section 5. And discovery statement भी है उसी के कहने पे the pistol was recovered. Section 27 में relevant होगा. Then the ballistic expert का opinion है the bullet was shot from that. So ballistic expert का opinion section 45 में plus section 9 में the identity of the pistol, identity of a thing, identity of murder weapon, that is relevant under section 9. क्योंकि उस फैक्ट के लिए एक्सपर्ट ओपिनियन सेक्शन 45 में, that will also be relevant under expert opinion. Now then this part, the conduct of the servant running to the school and informing the sister, and then the conduct of the sister to running to the spot and running to the police station and lodging the FIR, उसको conduct की तरह देख सकते हो, लेकिन that would be relevant under section 6 as a part of the same transaction because that was spontaneous and continuous. That was spontaneous and continuous, so that was a part of same transaction. अब बताइए इतने एविडेंसेस पर आप कन्विक्ट करोगे या क्विट कर दोगे? उनमें से एक आध नहीं होते, जैसे आई विटनेस होता, डिस्कवरी स्टेटमेंट होता, थोड़ा प्रीवियस कंडक्ट होता, तो इतना भी होता तो सफिशिएंट था कन्विक्ट करने के लिए. बट हियर देयर इज सफिशिएंट सर्कमस्टेंशियल एविडेंसेस and therefore this case is total fit case for conviction. But the problem that happened was that the accused has raised the objection, and the objection is that this eyewitness who had given the testimony, क्योंकि इस केस में तो pivotal evidence तो eyewitness की testimony है, तो उसने और भी objection उठाए थे डिस्कवरी स्टेटमेंट वगैरह एक्सेट्रा एक्सेट्रा, पर जो मेन ऑब्जेक्शन था कि eyewitness है जो वो interested witness है, because he was the servant in the same house in which this man stays, and therefore that is a planted witness. He was not present on the spot. He is giving a false evidence. Plus the other thing he is claiming is, एक तो आई विटनेस को उसने डाउट में डाला, plus other thing he is claiming is that I was in the factory. I had reached there at 8:30, 8 or 8:30, and since then I did not come out. I came out only once, and that is for lunch, and after the lunch I was chewing pan and I was about to get into the factory when these persons arrested me. And his friends and colleagues in the factory, they have strongly given evidences in his favor. उन सब ने एविडेंस दिया उसके फेवर में that he never left out, he was in the factory. अब 9:45 के आसपास मर्डर हुआ है और 8:30 बजे ये फैक्ट्री में था, तो फिर निकला ही नहीं तो मर्डर किसने किया? So that is the point he is raising, that I was in my factory at 8:30, I never came out of the factory, and therefore I have a plea of alibi. और उसके फैक्ट्री में ये रूल था that whenever you get inside to the factory there is a card that should be punched. That card has to be punched. जब भी कोई अंदर जाएगा तब, और टाइम लिखा जाएगा. लेकिन जब वो बाहर आएगा then there is no punching. जब वो बाहर आएगा then there is no punching. लेकिन जब दोबारा अंदर जाएगा then again it would be punched. So the system is, if you went into the factory at 8:30 and the card is punched, then the time is noted. But if you came out of the factory, then there is no record of that. If you again get inside, then again it would be, there would have been a record. So that is one point. But his friends give a strong evidences in his favor. अब what the court held is, it examined that eyewitness. Eyewitness की testimony को examine किया गया. And the question obviously was a doubtful part, that the eyewitness is the same person who is working in the house. In 9:45 in the morning, how can the servant of the house is out of the house to visit the Hathi Park? That is quite logical. If he is the servant in the house, then he has to do so many household activities. तो वो सुबह सुबह 9:30-10 बजे हाथी पार्क करने क्या जाएगा? कैसे चलाया जाएगा? उसको काम से छुट्टी मिलेगी तभी तो जाएगा. So that point was raised and it was held by the court after examination that the servant being on the spot is quite possible, because that was the day of एकादशी, और एकादशी में परिवार में सबका व्रत था. It was एकादशी का day and it was a व्रत of fasting of all people, and there is nothing to prepare to cook in the kitchen, and there is no utensils to clean, and there is a friend of him from Kanpur and he want to visit the Hathi Park, and this servant took the permission from the lady, from the Malkin, and he took his friend to visit Hathi Park. Because it was the morning time, there was no one and they were free to do it. Because afternoon, they were not free to go. So that is quite logical that he was there. Plus जो separate बयान लिए हैं कोर्ट में, क्योंकि जब भी 2 या 2 से ज़्यादा लिस्ट होंगे विटनेसेस, तो उनका बयान अलग अलग रिकॉर्ड किया जाएगा और ये देखा जाएगा कि इनके बयान में इनकन्सिस्टेंसी है कि नहीं. तो उस सर्वेंट ने भी बयान दिया, उसके फ्रेंड ने भी बयान दिया, एंड द कोर्ट फाउंड दैट द स्टेटमेंट ऑफ दीज 2 विटनेसेस इन द कोर्ट वाज टोटली corroborate each other. There is no inconsistency. दोनों ने बिल्कुल सेम टू सेम बयान दिया. Plus the most important, the FIR that the sister had lodged, that was in the same transaction spontaneously, and she had stated in that my servant had said so and so. So whatever she had lodged into the FIR, exactly the same statement is of the servant and the friend in the court. So is it not the evidence it gives? The evidence he gives in the court is corroborated by his previous statements. क्योंकि previous statement दीदी को दिया था ना उसने, क्योंकि दीदी को जो बयान दिया था दीदी ने रिकॉर्ड करा दिया था उसको, मतलब उसका एक रिकॉर्ड है कि उसने ये बयान दिया था मुझे. और कोर्ट में जब वो बयान देता है, that testimony in the court is corroborated by the statement that he has made to the sister. And how is that statement is proved? Sister stood in the court and gave the testimony, और sister ने वही बयान FIR में लिखवाया है. So FIR will corroborate the testimony of the sister, FIR will corroborate the testimony of the sister, and sister will corroborate the testimony of the servant into the court. And therefore it was held that the servant's testimony is trustworthy and they was actually eyewitnesses. That fact has been proved. तो ये जो ऑब्जेक्शन रेज हुआ था आई विटनेस वाला, दैट ऑब्जेक्शन हैज बीन डिस्कार्डेड. अब अगेन द सर्कमस्टेंशियल एविडेंसेस आर वेरी स्ट्रॉन्ग एंड देयरफॉर द एक्यूज्ड शैल बी कन्विक्टेड. बट अगेन द पॉइंट इज दैट ही वाज ऑन द पान शॉप एंड ही रीच्ड द फैक्ट्री एट 8:30 एंड हिज फ्रेंड गिव द टेस्टिमनी दैट ही नेवर लेफ्ट द फैक्ट्री. अब द कोर्ट एनालाइज्ड दैट एंड फाइंड दैट देयर इज ए स्लाइट डाउट इन देयर. Even though his colleagues give testimony in his favor, there is slight doubt that your colleagues may support you, that you may have done a wrong. And कि आप फैक्ट्री 8:30 बजे गए, that is proved. लेकिन 8:30 जाने के बाद तुरंत बाद निकल गए, then 9:30 you can always reach Hathi Park. So you went inside the factory, that is fine. But you are not able to prove that you never left the factory. You prove the evidences of your colleague, but ultimately you found outside the factory and no second punching was done. लंच टाइम हो गया था, काफ़ी देर हो गया था, आप अंदर नहीं, फिर भी आप अंदर नहीं गए थे, एंड देयर इज नो सेकंड पंचिंग, वाई? बिकॉज यू वांट टू स्पेंड टाइम आउटसाइड द फैक्ट्री so that the second punching is not done, otherwise it will prove that you went inside again. And there is a slight doubt regarding the fact it is not proved that after you entered at 8:30 you never left the factory, and ultimately you are arrested outside the factory, and you may have left the factory for lunch, or you may have left the factory at 8:35 only, who knows? जबकि circumstantial evidences are totally against and strong against you, so a little bit of doubt regarding the alibi is sufficient for the rejection of the plea of alibi and sufficient to convict you. So I am just trying to tell you through this case that how the court approaches the plea of alibi. अब उसके फ्रेंड ने भले ही बयान दिया है कि ये कभी नहीं गया था बाहर, लेकिन हम ये मान सकते हैं कि घटनाएं कभी झूठ नहीं बोल सकती। सर्कमस्टेंसेस नेवर टेल्स लाई। घटनाएं चीख चीख कर बोल रही हैं कि आप ही थे जिन्होंने मर्डर किया, क्योंकि आप जो कहानी बता रहे हो एलिबाई वाला, उसमें थोड़ा सा डाउट क्रिएट हो गया कि आप कितने बजे निकले, ये प्रूव नहीं कर पाए आप। अगर आप ये प्रूव कर देते कि लंच के टाइम पे निकला था, कोई ऐसा डॉक्यूमेंट होता, ये प्रूव कर देते, तो फिर बात अलग होती, लेकिन ऐसा कुछ प्रूव नहीं हुआ, एंड देयरफॉर द प्ली ऑफ एलिबाई वाज रिजेक्टेड। अब इस केस को आप पढ़ो, प्रिंट आउट निकाल के पढ़ो, आपका लेवल काफ़ी हाई हो जाएगा। अब इसी केस में अगर सर्कमस्टेंशियल एविडेंस इतने स्ट्रांग नहीं होते और तब उसके फ्रेंड्स ने ये स्टेटमेंट दिए होते और प्ली ऑफ एलिबाई, तब उसको प्ली ऑफ एलिबाई का डिफेंस मिलता। अब जैसे आई विटनेस ही नहीं होता, तो आई विटनेस नहीं होता तो ना एफआईआर वाला बयान होता, ना वो उसकी बहन कोर्ट में आके दोबारा बयान देती, वो कोरोबरेट होता। तो मिला जुला के ये जो एविडेंसेस आपके पास ये नहीं होते, तो इस केस में आपके पास सर्कमस्टेंशियल एविडेंस स्ट्रांग नहीं होते, तो फिर जितने होते सर्कमस्टेंशियल एविडेंस उस पर आप कन्विक्ट कर सकते थे। नहीं, ये एक डाउट है, तो सिर्फ एक डिस्कवरी स्टेटमेंट और कंडक्ट और मोटिव पे कन्विक्शन नहीं होता। सिर्फ डिस्कवरी स्टेटमेंट, कंडक्ट और मोटिव पे कन्विक्शन नहीं हो सकता, एंड देयरफॉर द एविडेंसेस कुड हैव बीन वीक। तो उस केस में तो सिर्फ शायद उसको प्ली ऑफ एलिबाई की ज़रूरत भी नहीं पड़ती, वैसे भी एक्विट हो जाता। लेकिन अगर उस समय भी प्ली ऑफ एलिबाई लेता है, लेकिन जो कोर्ट का स्ट्रिक्टनेस है वो तो वही रहेगा। कोर्ट लिबरल तो नहीं रहेगा कि प्ली ऑफ एलिबाई देने को। कोर्ट आपको इस ग्राउंड पे एक्विट कर देगा कि द चेन ऑफ सर्कमस्टेंशियल एविडेंसेस आर नॉट स्ट्रांग कंप्लीट। लेकिन प्ली ऑफ एलिबाई में डाउट तो फिर भी रहेगा कि तुम कितने बजे गए, ये तो प्रूव हो गया, बट व्हेन यू केम आउट दैट इज नॉट प्रूव्ड। तो उस केस में तो वैसे ही बेनिफिट ऑफ डाउट की ज़रूरत नहीं पड़ेगी, क्योंकि सर्कमस्टेंशियल स्ट्रांग नहीं हो पाएंगे एविडेंसेस। सॉरी, बेनिफिट ऑफ डाउट तो वैसे ही मिल जाएगा, सर्कमस्टेंशियल एविडेंसेस इतने स्ट्रांग नहीं है, तो उसमें प्ली ऑफ एलिबाई की इतनी ज़रूरत नहीं भी रहेगी। सो दैट्स इट फॉर दिस टॉपिक एंड दिस लेक्चर। थैंक यू फॉर वॉचिंग लेक्चर।